Sorry, Wendy. Yes, I do.
Okay, so let's have her do that first.
All right.
Great. Thank you. Are we recording?
Yes, I saw it pop up.
Okay, awesome. This is a regularly scheduled meeting of the Tennessee State Board of Accountancy Committee meeting, which is taking place via teleconference on Monday, May 3rd, 2021. Notice that this meeting was posted to the board's website on April 27th, 2021. Because there is not a physical quorum present, a statement of necessity is read into the record and filed with Tennessee Secretary of State as required by statute, pursuant to TCA 844-108B2. If a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. That determination must include a recitation of the facts and circumstances on which it was based. Further, TCA 844-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communications is necessary. The purpose of this meeting with members attending by teleconference is to conduct a quarterly scheduled meeting of the board. This meeting was scheduled during the time period covered by the executive order that allowed for virtual meetings of the board. To change today's meeting to in-person between the expiration and the scheduled time was impractical due to the logistical requirements of securing travel arrangements and hotel accommodations. Furthermore, the necessity of the execution of this meeting is due to the need to timely process consumer complaints to ensure the efficient resolution of matters, as well as address regularly scheduled matters of the board. All voting will be conducted by roll call. Thank you.
Thank you, Maria. And just kind of an announcement, if you're not speaking, you may want to go ahead and mute your microphone, except during the time when you are speaking, just to kind of prevent any extraneous noises here from popping into the meeting. And we will go ahead and begin with the licensing committee. And Gail, it looks again like you're leading the workhorse committee of the board here. You've got some items that require action. So, Madam Chairperson of the committee, I'll turn it over to you.
Thank you, Kevin. Hopefully this will be much briefer than last time. So the first thing on our agenda is the consideration of the Certified Data Privacy Security Engineer exam. This, we have been requested to consider this to add to the approved exam list for CPE credit. This certification is provided by the Information Systems Audit and Control Association, and it validates the candidate's knowledge of data privacy, specifically addressing governance, architecture, and the data lifecycle. This skill set is essential for CPAs that in the IT audit space who are consulted on privacy issues and are required to investigate privacy risk, which was, we all know this is becoming much more common. The exam is 3.5 hours in duration, and this would translate into 17.5 CPE hours based on our rule transitioning the hours of the exam to the CPE hours. We were provided a list of similar exams that have been approved in the past. 2 of those are with Information Systems, the Certified Information Systems Auditor and the Certified Information Systems Manager. It has been recommended that we would consider this as information technology for the technical area of CPE. Any discussion?
Stephen, I think this is a reasonable request and it's consistent with what we've done in the past. And I would, unless somebody else wants to talk, I would make a motion to approve this request or recommend to the board we approve this request.
I agree. Wendy, we have to vote on this. The committee does. Is that correct? We have to vote to recommend to the board that we would approve this exam.
Wendy, you may be on mute.
Sorry. Yes.
Okay.
So we need it. So I think we need a second.
Do I have a second?
I'll
Second.
Okay, roll call vote, please.
Gay Moon,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
John Griesbeck.
Okay. The second item on our agenda is looking at an accounting ethics course, Management 59,000 from Purdue University to qualify for an upper division accounting credit. We have previously approved some other ethics courses to meet the upper division accounting requirement, and this is another one. Sherry has reviewed the course syllabus. We were provided with the content as well as a list of the resources. And these resources were very accounting specific. So while it starts out as a more general ethics course, it does utilize accounting ethics done by McGraw and Hill, as well as the NASPA Student Center for the Public Trust Ethical Leadership Certification Program, the AICPA Code of Professional Conduct, the Texas Rules of Professional Conduct. So we're just asked to review this and see if we would approve it for an upper division course. Any discussion?
Stephen, again, I think that similar to the last request, I think this is a reasonable request. I think our staff has determined it does meet our standards, and I would be willing to make a motion to approve it, request approval or recommend approval by the full board.
Is there a second?
I would second it. I had looked through this pretty thoroughly and agree that it's very accounting oriented, which for me is the major criterion.
Okay, we're ready for a roll call vote.
Gay Moon,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
John Griesbeck.
Aye.
Thank you.
Okay, the last thing on our agenda is World Education Services. When we have international students who get an education abroad, their coursework has to be evaluated, and there are different companies that provide these evaluation services. NASPA also has an evaluation service for international students. We've had some candidates from India that have worked through the World Education Services to get their education approved to sit for the exam, but there's some inconsistencies. Mainly, they have a 3-year program, and our rules and regulations require a 4-year program. So we've been asked to kind of look at this and really look at World Education Services and whether or not we would continue to utilize this or approve them for this equivalency studies. We have been provided with a list. World Education Services is not the only company that the Tennessee State Board utilizes. NASPA has their own international studies, and then there were several other entities that provide this service. So if we decided not to approve them or to discontinue accepting their reports, students would not be out of luck, so to speak. And then I thought it was very interesting. Wendy sent out a quick poll, and we had 23 states respond. And of those 23, 20 said they do not accept World Education Services. And the reason primarily is because of the inconsistencies in the way they apply their, how they review the coursework. And again, in India, which is the country education that we're looking at, they have a 3-year program versus a 4-year program. So I'll open it up to conversation and comments about what you all are thinking.
Wendy, could you give us some background about NASBA's thinking on this and how they came to do their own evaluation? Obviously, they would recommend that over this. I know that I've dealt with, believe it or not, even at Rhodes, we've had students who came into, two students who came to our masters who had 3-year degrees from elsewhere, and I know it's controversial. So anyway, I was just curious about how long has NASBA had their own service, and is there any downside to just using NASBA?
Yeah, I think the recommendation today is not to only use NASBA. The recommendation here is to cease approving WES. So we do have a variety of other services that applicants can use. NASBA has not agreed with WES's review of the 3-year education from India. They do not agree that it's equivalent to a 4-year undergrad degree in the US. And so that has been their stance as long as I've been here that I can remember. So they said they had done some research a few years ago. I did talk to Pat Hartman, who is the director over the exam services side and education evaluation, and she said that they just don't agree with WES's review of the undergraduate program, and they have actually talked to WES about being equivalent to the other international educators, and would they change their stance, and WES isn't willing to change their stance either. And so there's just a disagreement there among how the education in India is reviewed and determined to be equivalent to that of a bachelor's degree in the US. Does that help at all?
I personally have a major problem with their lack of consistency. I don't know a lot about the company, but I did kind of check around, and it seemed to be a consistent feedback that there was some consistency issues between them and the other states, or the other reviewers, I guess. And
the other companies.
Yeah, it speaks a lot. Just looking at the states you polled, there was only 2 or 3. Was it 3?
3 that accepted them.
I don't think I could. Well, I would not be for continuing to use them.
And I agree with that assessment from what I've seen, I think. But there are other good services. I would hate for us to have to do this by ourselves. But because there are other good services, I think this is not the one we want.
So am I hearing that this would not present any particular hardship for a candidate because there are other services we can use?
Great. John, that was my view on it was, you know, I was hesitant with this, but we started, I think part of the reason this came about was because they opened up testing in India last year. And so we have a lot of candidates now that want to test in India. And so it kind of heightened the issue last year when we had several coming to us saying, you know, I've gone to WES and now you all aren't accepting the 3-year program. And so that's kind of how this came about. And I wanted to be fair to WES. So I had a long conversation with them and fair to the applicants as well. And, you know, my one hesitancy was WES is a very large organization. They've been doing this a long time. They are solid in their belief that this is equal to that of a bachelor's degree in the US, but then I have other concerns that other companies don't treat it that way. And I feel like with we have several other options for licensees. So I don't believe that this would create a hardship for the licensees because they have several alternative companies to go to get this service provided. NASBA is one of those.
Thank you.
Wendy, would you spend just a couple of minutes, because we're wanting to make this, if we decided to eliminate WES as an approved resource for this purpose, we want to make this effective August 1. Could you give us a little bit of background about how many current candidates are in the pipeline and how we came about with the August 1 effective date.
Sure. So I don't know how many candidates are in the pipeline, but we have to assume there are some in the pipeline right now. And in my discussions with Pat Hartman at NASBA, I wanted to come up with a realistic time frame to not disadvantage those that have already sent their transcripts and paid for an evaluation under WES. And so it was felt that really 60 days was an appropriate time frame. And so I chose the beginning of the month of August as an appropriate time frame. We would then communicate that to WES and to NASBA so that those in the pipeline can get through that process. And it doesn't necessarily mean we have not been accepting that 3-year degree, just so everyone's clear. What happens is WES submits a report saying their education is equivalent. It gets to NASBA for their review, and then they have gone and said, well, we know that WES says it's equivalent, but it doesn't meet the law and rules in Tennessee, and so you are missing X amount of hours. And so it's not like we've been accepting it and now we're not going to from the actual education part of the report, if that makes sense.
So this would also save candidates some money by not having them go to getting as far as NASBA and then having it, say you're not meeting it. This would steer candidates to another organization, and they could look and maybe save a little bit of money in those kind of fees.
Correct, and not be surprised down the road when they find out that it actually isn't accepted. And in the meantime, to alleviate this, since this first came up really last summer, was we added some documentation to the website and tried to notify folks that this indeed was how we treat these things, and that they might find themselves short. Some applicants have taken a significant amount of education and they end up being fine. They have enough, but some folks are not.
Okay. Well, is there any other discussion? Okay. Is there a motion on the floor to withdraw approval of WES reports effective August 1, 2021, to ease the confusion for licensees and maintain consistency with other jurisdictions?
So moved.
A second?
I'll second it if I wasn't the one that made the motion. I think we talked at the same time.
Likewise.
John, you can have the motion. I'll make the second.
Yeah.
Okay. Roll call vote, please.
A Moon,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
John Griesbeck.
Aye.
Okay, that concludes the agenda for the licensing committee. Thank you.
Thank you, Gay, and thank you, members of that committee, for working through those agenda items. We'll go next to the Enforcement Committee. Looks like we don't have near the number of complaints that we would typically have, I think in part because our CPE audit results have continued to be so much better than in prior years. But we do have a few that we need to process. And Andy, I'll turn it over to you as that committee's chair.
Okay, can everybody hear me?
Yes.
I was having an
Yes.
issue with my microphone, so I finally got that fixed. And you are correct. We've got a great report today from legal. We only have 7 cases on it. I'm going to pull up first and talk about our case and compliant report. Everybody got a copy of that. Happy to report that there's 19 cases on there. With the 7 we actually have that are going to be in the legal report today, we actually have 26 total. Those are not included on that report. But if you kind of browse down the report real quick, you can see that we got 5 that are in process. We've either requested information or legal is reviewing them. We've got 3 that are currently being investigated, and they're yellow. And then we've got 4 consent orders that have been authorized, and they are green. And then we have 4 with payment plans, and they're the pink ones. And then we have 3 that are legal monitoring. And so for a total of 19 that we have on that open compliant detail report. So just kind of a quick update there. The legal cases today are we got.
Hey, Andy,
Yes, go
can I
ahead.
ask a question about that report?
Yes, sir.
And this may be something that Wendy might have to answer, but what has to happen for a case to fall off this list? In other words, we've got some on here that the consent order has been authorized. So does that mean it's been authorized but not signed yet? And then once it gets signed, it'll come off? Is that how that works?
That my understanding is that the consent order has been authorized, but we haven't received an acceptance back on it.
Okay, so one in particular that I want to ask about is, I made a copy of these, and my printers, the color in my printer ink is not working right, so I can't say green, pink, or red. I'm not sure what color it is. But the last one that's under legal formal charges authorized, it's and it has a 2018 date on it. Is that the one, Maria? Is that the one we had the informal hearing with? And that one's kind of old. Is the reason I'm asking about it.
Well, Larry, I can look on that really quickly. I believe it's Stuart's case.
Yeah, Maria,
Correct.
I know I put this together, so you might have a harder time, but that is Stuart's case, and we really hope to have a resolution at the next meeting on that case. You're right, the consent order was authorized, and the respondent just has been unwilling to agree, and so we have been working through that with the
Okay.
respondent.
Yeah, the fact that it was authorized but wasn't signed, and it's been so long, was what my question was about.
And Larry, just to answer your question, it wasn't the respondent that you and I had the informal conference with. This is a different respondent.
Okay. All right. Thanks.
Any other questions on the open complaint detail report? All right, seeing none. Basically, we've got, as I said, 7 cases. We have 5 under the consent side. Basically, from there, we have 3 that are case 1, case 2, and case 4 holding out as licensees. The first 2 cases, 1 and 2, they were holding themselves out as accountants. And so the recommendation there is to close with letter of instruction and to remove all references. Case number 4 is the person was holding out themselves as a CPA, but they weren't licensed in the state. And so that one is to close with a recommendation of just a warning letter. And then acts as credible, a violation of mask order. And obviously we don't have any legal authority in that area. So just close that case. And then a self-reporting. We had a licensee who reported a civil case. And so that he's involved in an ongoing civil matter. And just recommendation there is just to inform the board if he or his firm was found liable in any matter. Those are the consent agendas, and I ask if any of the committee members have any questions related to those 5. All right, so with those 5, we'll break them down as consent and then proposed discipline.
Andy, I'm not a committee member, but could I ask a question?
Yes, sir.
On number 2, this is kind of technicality, but on number 2, it says in the first sentence, board received a complaint against the respondent from another licensee. I don't think that other person was a licensee, the one that we're talking about, the respondent. So should that just say a licensee? There's not two licensees involved there. There's one person who is and one person who isn't.
Right, the licensee is the,
It says the complaint against the respondent.
I see what you're saying there.
I was gonna say, actually, a licensee did file the complaint against oh yeah, I see what you're saying. The respondent's a non-licensee.
Yeah,
I see what you're saying now.
probably
Make
just
an
need to
amendment to
correct
correct
that.
that before y'all finalize tomorrow.
Okay,
Okay, then on number 4, these are all quick questions. Number 4, it says the respondent submitted a response stating he didn't knowingly violate the law. Since he was a licensee in Maryland previously, are we treating this the same way that we would if he was a previous Tennessee licensee? Because he knows he wasn't supposed to do that if he was a previous licensee in any state. So we're saying give him a letter of warning, but if he was licensed in another state, in Maryland, and it just expired, I don't think he can claim that he was unknowingly claiming to be a CPA and not violating any rules. I'm just asking. I'm just saying if he'd been a Tennessee.
I guess I read that one different than you did, Larry, because I read the fact that he didn't realize that he was on those social websites still listed as a CPA. Is that how it came across, Sharon?
Well, he was unaware that his licenses had expired. That was
Okay.
one of the situations. The respondent is no longer practicing and was unaware of the expiration of the license in Maryland.
And he also indicated that he was going to take steps to get his license in compliance in Maryland. But he was very, very thorough in his response. I will say that. I think so.
Okay. And one more on number 5. Says it's a malpractice case on tax refund prep. It almost sounds like we're just taking the attorney's opinion that it's out of the statute of limitations, and it almost, the wording sounds like we just asked the attorney what he thought, and he said this, and so we're going to move on.
So the intent behind that, Larry, is that just because there's no violations at this point, the board doesn't have any authority, to discipline at this point. So we were just going to instruct the licensee that in the event that they are found, negligent in the matter, that they would then have to report to us. But at this point, these are just claims, and so there's something we can really do at this point.
Okay.
And I'm trying to be consistent from our last legal report where we decided, to just make sure that we have on file in their licensing file that, we did put them on notice that if the violation occurs, and that's when, the board would intervene.
So it's basically
If I
on
recall, Maria, you actually referenced a section in the law that says that they need to report if there ends up being an issue.
Yeah.
Okay.
So Larry, can I add something? So the reason that we have people report this is on the renewal application. You all may recall that when you renew your license, it asks if you've been party to a civil case or something of that nature. And so folks self-report as part of that renewal process. And sometimes it's just beginning, and sometimes this drags on for a few years, and we have this open complaint sitting around. And so what we're trying to do is alter that process a little bit to where we have them report on the back end once they've been found liable, so that we can then handle it once decisions have been made. Is that a fair summary, Maria? And we're going to try to change that wording on that renewal.
Yes, that is correct. Thank you, Wendy, for explaining that more. That is helpful, to point out that sometimes these matters will go on for years, and often the resolution is settled and there's never a judgment entered against either party. So it's just better.
So if they respond on the license or renewal application by saying that, yes, I do have something going on. We treat that as a self-reporting, even though they didn't report it without being asked.
Well, maybe I used the wrong terminology, not really self-reporting, but they report it and we open complaints. The history of the board has been a complaint is opened at that time to follow the case and the situation.
Okay.
So.
All right, I'm done.
Any other questions? All right. At this point, we ask for a motion to approve all the consent.
So move.
And a second. All right. And so I ask for a roll call, please. Roll call vote.
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Greg Gilbert,
Aye.
Todd Skelton,
Aye.
All right. The next ones are the proposed discipline. We have two unauthorized activity issues. I found it on number 6 there that the owner of respondent firm is registered as CPA in the state of Illinois, and the registered CPA is not permitted to perform review, audit, or test engagements in the state. The respondent stated that the client initially requested a compilation engagement, which he thought the firm could complete. However, it was later discovered that the review engagement was required. Under intense pressure from the client, the firm agreed to complete the review engagement, knowing the firm was not licensed to issue a review report. Very costly. It should be noted that the respondent is offering compilation services at the firm's website. The investigator explained to the respondent that compilation engagements are also restricted to active CPA license with a firm permit and peer review enrollment in both the states of Tennessee and Georgia. So the recommendation is that authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of the civil penalty in the amount of $1,000 and TCA 62-1-113 for issuing a review report to Tennessee client without proper licensure, and also to refer other violations to respondent's home state of Georgia Board of Accountancy for use of the CPA designation and offering compilation services to the public. On the second one, we also have a referral from Tennessee Board of Licensed Contractors. For an unlicensed, the respondent was not licensed in the state of Tennessee or any other state and was not enrolled in peer review. But they were using the accountant designation and actually issued a report. The client states that it was a misunderstanding was hers. She had actually called and gotten a representative that said that she had asked if an LPA could provide the report, and they stated supposedly from her desk that they could. But she at the end comes back and says, well, it's my issue. I misunderstood. And so the last thing is that it should be noted the review report issued on the balance sheet was not in conformance with current guidance containing the statements on standards of accounting and services SARS. However, the respondent did use report language in the report that did not use the safe harbor language required by board rule 0020-4-.06. So this recommendation is to authorize a formal hearing with the authority to settle via consent order with a payment of a civil penalty of $750 for issuing a review balance sheet without proper licensure. So,
Mr. Bonner, can I jump in here again?
yes, sir.
I'm not a committee member, but here again, these terms are confusing me. Is there such a thing is it really such a thing as a registered CPA in Illinois? And is that different from a regular CPA? I mean, we're saying he's a registered CPA, which allows him to use or issue compilation reports. Is that a actual designation in that state?
I think Sharon's nodding that she kind of
Yeah.
understands that question.
Yeah, it is. The state of Illinois has a licensing where you have you've passed the CPA exam, but you have not yet met the experience requirement.
Okay.
And that's what they call a registered CPA. And they, in the state of Illinois, actually do permit compilations
Okay.
of registered CPAs, but not any other attest services like reviews and audits or anything under the SSAEs.
Okay. And then a similar question in number 7, where we're using the term LPA. I thought that was a term that went away a long time ago. We don't have it in public accountants anymore, do we? I mean, public accountants went away when we brought them all under our wing and started regulating them under the same board as, I mean, they used to be 2 different things. Now they're all, we're referring to this public accountant or LPA as if that's an actual designation in Tennessee.
Well, there are a couple of, I think there's, Wendy, correct me if I'm wrong, there might be a 1 or 2 people that are considered public accountants rather than CPAs under the old rules. But in this case, the respondent is neither a public accountant from back in the old days designation or a CPA. Just to kind of clarify a little bit of what happened in terms of contacting customer service is the advice that was provided is that if somebody had a licensed business, she called it an LPA, and then the individual asked, "What's an LPA?" I do not know what an LPA is. And according to the respondent, the customer service person told her that an LPA was an individual with a business license, and that was all that was required. And there was some confusion there between, what that really was. And unfortunately, if it had been somebody that she had contacted through the Board of Contractors, we could have talked to them, but apparently it was just somebody on the customer service line, and we just don't have the documentation to go back to determine when that was, and the respondent didn't have the name of the customer service rep either.
Yeah, I just don't think I don't think LPA is an actual thing anymore. In fact, I didn't think PA was anymore either, because our law says that nobody can use the word accountant other than CPAs. And so why would there be public accountants?
Larry, the public accountants are grandfathered in, and there are about 10 of them still licensed. But this is really just a matter of miscommunication when the client called the contractors board and spoke to someone, and we don't have.
So last question is, why are we charging the first guy $1,000 and we're charging this one $750 in the last 2 cases?
So 750 is the mitigating factors. That's what's on the discipline matrix for mitigating factors. So just in number 7, this individual who completed this was given misinformation, and we considered that. And then the $1,000 is the standard penalty for number 6, just because the person is, a registered CPA in Illinois and was more familiar with the, should have been more familiar with the rules, and we just did
And
standard
he knowingly admitted that he knew he could not do review engagements. So there was a bit of a difference there.
Anyway. Yeah.
Yeah, and he just did it anyway.
Okay.
Any other questions? All right, seeing none, I've got cases 6 and 7 under proposed discipline. Ask for a motion to approve.
So moved.
And a second.
Second.
And if we could get a roll call vote, please.
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Greg Gilbert, I'm sorry, I didn't hear that.
Mute. You got your mute on.
Aye.
Thank you. And Todd Skelton, please.
A sticky mute button or something.
Thank you.
All right, Mr. Chairman, that's all we have. We've got a short legal report this time.
Okay,
Can I ask a question before we go on?
certainly.
Well, two things. Wendy, I think you all said before that you're working with the contracting board to, I guess, educate them on requirements so that we can perhaps eliminate some of these cases from coming up.
Yes, and I had meant to put this in my director's report and forgot. So thank you for bringing that up. So I had reached, we had provided, Sherry and I had reviewed their application last spring, provided them some options for rewording it that might help them be aware of the requirements for somebody to complete these reports. And I touched base with the director of the contractors board, and they had not been able to implement those changes yet. But as of maybe about a month ago, they were going through the process of updating their application, and we're taking our suggestions into consideration to help make improvements there. I think at the last meeting, someone asked about even providing the license number of the individual and the firm and proof of peer review. And she wasn't sure they could go that far. She was going to work with her legal counsel to see if they could go that far. So that's still pending piece of the puzzle, I guess. So we'll see what happens. We'll see if we get any reduction in these types of complaints.
Do they have to positively affirm that they meet those requirements on the application, or is it just something they read and move on?
Well, remember, it's the contractor that's completing the application, and so you have the client stuck in the middle, kind of, is the one that sees the application, and depending on what they share with their CPA, sometimes the CPA may not be sure what they're providing the document for or the report for. So.
And one other question, I'm kind of regressing. I apologize for that. But on the open complaint detail, those items that were received in like 2016, 2018, are those, I guess, more or less in compliance with what was agreed to be done? Because they're so old, that's why I'm asking if they are still in compliance with whatever the agreed.
Right. So there's one there from 2016, and that's in the status of a payment plan. And so anyone in a payment plan is either complying, and if they don't comply with the payment plan, then their license, typically there's language in there that their license is revoked if they fail to comply with the payment plan. So that particular one is an odd one. The person's license was suspended, and the respondent has until February 22nd of 23 to apply to reinstate that suspended license, or it will be revoked. And so that's the unique situation of that one. And then the 2018 one is the one that I believe Larry asked about, where we are really hoping to have that resolved at the next meeting. That's where the board authorized the discipline, but the respondent has failed to agree to it. And so we're kind of at a pass where we either need to have a hearing or we need to get them to sign this. So we've been at an impasse, but we had some movement this past week, which was a little late, but we are hoping to have this finalized by July.
Okay. Okay, thank you.
All right, thank you, Andy, and thank you, committee members on the Enforcement Committee for diligently reviewing those cases. The next item that we have is the Laws and Rules Committee, and we actually have a draft rule change here. And so, Larry, I'll turn it over to you as chair of that committee.
Okay, thank you, Mr. Chairman. This item, as we all know, the accountancy rules and laws and rules have been changing for the last few years. A lot of things going on that are going to need updating. So this basically is within the accountancy laws and rules. There's a section or a chapter called 0020-02 that relates generally to educational and experience requirements. And that's one of the areas of the accountancy law that has changed a lot, and a lot of things are being updated and so forth. So such things as the CPA Evolution Project have caused things like this to be reevaluated. Current practices are causing things to be reevaluated. The UAA model rules that were adopted back in the fall for change that have affected things like this. So a lot has happened that has not been changed within the law itself and the rules in our booklet or in our code. And this model language here will help to do that. Now, there's a lot to look at. I'm going to ask Wendy to get into more details on some of these things, but I think the staff would love to have a decision today on this as far as so they can move forward. But having said that, there's a lot to read and a lot to review. Some of the things are new things. If you look at your detail behind here, you can see that there's a lot of cross-outs, but then there's also a lot of add-ons. It's interesting that some of these associations changed their names over the years and have added words that actually make it more confusing to know what they do. And as Wendy was telling me this morning, when I was talking to her about this, you can now, colleges and universities can now get a certain part of the university or a part of the school, like a business college, accredited differently or by a different group than what the university itself is. So lots been going on. So Wendy, I'm going to kind of just turn this back over to you because there's a lot here that you can explain, particularly the background behind all this and some of the details. So I would certainly appreciate you going over some of that.
Okay, thank you, Larry. As Larry mentioned, there are really two reasons why we're bringing this suggested rule change to you today. One is to update accreditation language to meet the current practices. And the second is to take some of the language in the model rules that was recently updated regarding education and make those changes in our rules where it makes sense. The model rules for education and accreditation are much different than ours, so it's not easy to incorporate them unless you did an entire cut and paste, or cut ours away and add theirs in. So we tried to suggest changes where it made sense and where it would improve our rules to keep up with the evolution project. And so on the first page of the red line version that I gave you, we talk about recognized colleges and universities. And so in number 2 there, basically what happened in 2009 is that the term regional accrediting agencies went away, and the U.S. Department of Education now only recognizes accrediting agencies. There's no regional, there's no national, it's just accrediting agencies. And so we took out that reference to regional since that term is going to be fading away. And then we updated the terminology used by each of these accrediting agencies. And then at the end, we added some of the accrediting agencies that were not previously mentioned, but needed to be added because we no longer reference the CHIA, and I'm trying to think of the what that acronym's continuing higher. Let me see what that stands for. Council for Higher Education Accreditation. And so at the very end there, under H and I, you have some accrediting organizations, as Larry mentioned, that accredit business programs and accounting programs. And we just wanted to make sure that there are some very worthy schools, as NASBA tells me, that are accredited there that might not be accredited under the other groups. So we just want to make sure we're catching everyone that we had approved before in this rewrite, and this should accomplish that. And before I go on, I will let you know that Maria and I went through these a couple of times and came up with what we thought was a good draft, and then we sent them to NASBA for them to review, and they had 2 individuals on staff review them, including Dan Dustin, who is has been involved with the UAA committee and their revisions of the model rules in this area. And finally, we did let Todd Skelton take an advanced look at these. So we feel like we've done some homework here, not to say that you all aren't welcome to make some suggested changes, but just to give you a sense of where we've been as we've drafted these for you. In number 3 there, you will see we marked out the first sentence, and that's because that list no longer is no longer there. It's no longer relevant. So we needed to remove that from the rules. And so the second part of that section, as it's always been, if an applicant has a degree from a university that's not accredited, there are options later in the rule that advise them on how to go about getting their education accredited if it wasn't, or acceptable, I guess is the right word. Under number 4, we just did some cleanup there to remove references to his and him, to change that just to applicant. So that's a little bit of a cleanup. Now we'll go on to the second page. That covers the accreditation part of it. And so those are really the changes that we're making to accreditation. Before I move on to education, does anyone want to talk about the accreditation or have any questions? No? Okay, I'll move on to the education part. So the education part, again, we are looking to incorporate 2 different things here. Some wording from the model rules that were adopted last fall, and second, to adopt some language which you all have used previously as a basis for accepting accounting courses, but wasn't always clear in the rules. And so we wanted to make it more clear. So I'll go through that. Under education, we talk about an applicant being required to have 30 semester hours of accounting education. And basically that's where it ended. You all had the authority to say what accounting education was, and it was very broad, which is good in some aspects, but sometimes it's hard for the applicant to understand what would be counted. And the model rules did a pretty good job of outlining various subject matter that should be counted under accounting education. So we added that. And again, this part came from the model rules. The following courses qualify as accounting education, and you have 1 through 17 there. And if you will notice, we added data analytics in number 15, which has been a topic of conversation recently as being something that should be accepted in the accounting realm. And on number 17, you have other accounting related content areas included in the Uniform CPA exam blueprint, or as may be approved by the board. So this gives you the authority, if you find something that's outside of one of the subject matter areas that is on the exam blueprint, or you all feel otherwise that needs to be counted as accounting, it gives you some leeway there to add that. And so before I go on to the next one, are there questions that pop up for that section on education?
Wendy, on number 15, does in an accounting context refer to all those subjects in that sentence before that phrase?
Yes. Are you comfortable with that? Do you think that's going to make it difficult?
No, I think that's what people will assume. I was hoping that was the case.
Yeah. So you're worried that in an accounting context was only related to digital acumen?
Right. I just
okay.
Wondered.
So I guess either of our attorneys, if you have any concerns with that, we could look at that. So accounting context is supposed to relate to all of those subject matters in 15, data analytics, data interrogation, or digital acumen. Any of those should have an accounting context to count. Okay. B is something that was in the model rules, and we felt like it helps you as a board determine what you're looking for when you're looking to count a course towards accounting. And so I'll read this out. In order to be considered by the board for approval, any course must be specific to accounting majors and provide foundation in accounting course subjects. The board will consider the following factors in determining whether courses qualify. And so before I read those following three, the words I want you to pay attention to are specific to accounting majors. So in the past, we have counted courses that are really meant for accounting majors. Many schools have separated out certain accounting courses and made similar courses of different rigor depending on whether they are for accounting and majors or not. And so that's a section I just want you to pay attention to on whether that's important enough to be in there or if you want to make any revisions there. The board will consider the following factors in determining whether courses qualify. The course should develop the skills required to apply the knowledge attained, including skills in communication, critical thinking, research, and analysis. Include and emphasize ethical behavior, professional skepticism and judgment, and professional responsibility, and provide quality instruction in subjects that clearly contribute to the knowledge, skills, and abilities necessary to meet the public's expectations of a CPA. So that came from the model rules.
So Wendy, this is Kevin. One question concerning that specific to accounting majors clause that you mentioned. I think many programs, at least that I'm familiar with, allow intermediate accounting to actually count as a finance elective for finance majors. And certainly it counts, or at least I've seen it counted as an accounting elective for accounting majors. But under that scenario, I'm not sure I could argue that it's specific to accounting majors if finance majors are allowed to count that as an elective. So I guess that raises kind of a dilemma for me as to what does that really mean. I would sure think we would want to continue to include intermediate accounting as a qualifying course.
I agree. I had thought about that, and actually most schools will let anyone take intermediate regardless of major if they have the prerequisites. Could it say counted toward the accounting major rather than specific to?
I can work, this is Maria, I can work on some language for that. I see what you all are saying, and I think that was the intent, but it's good to know that, this scenario could make it cloudy. So I can, oh, sorry, go ahead.
I was just saying it really can't be exclusive to accounting majors because there are very few courses that have that trait.
Okay, that is helpful.
I worried about that with regards to data analytics type courses as well. I mean, we may be looking outside of accounting specific. And so we were just trying to find a way to put in the rules the concept that you all only accept courses that have the rigor intent for those individuals sitting for the exam, because there are some courses we have not been counting because they're titled not meant for accounting majors.
What about appropriate for the accounting major? Anyway, I will trust you, Maria, to work on the words, but that's what I was thinking. I think Kevin and I were on the same track there.
That's very helpful. I'm thinking something along the lines of qualify as, but I don't want to just off the cuff come up with that and sound silly, but something, saying that it would qualify towards a degree in accounting or an accountant major.
Okay.
But I think the items we've talked about, like Kevin's question about finance and intermediate accounting, I think that would already be covered under 1A, would it not? And then 1B, the same really with respect to data analytics under 1A15. So it seems to me that 1B is for other action by the board. And I may be reading that incorrectly.
I believe the intent of this paragraph was to add on to A, meaning to help from
Right.
an approval standpoint.
And that's how I read it.
Yeah.
Actually, that brings up another point. The lettering of that is confusing in that regard because you have A, which lists the accounting qualifications, and then B that simply says, in order to be considered for approval. Because this is B, it seems to apply to all of number 1, not specifically to A. So it seems like it should be approval as an accounting course or approval in part A. Do you see what I'm saying? This is not a subset of A. It is a subset of number 1.
Okay.
Okay. I just want to make sure I'm understanding, because the way I look at it is, 1 is the overarching of what will qualify, and then A goes to list each individual course, and then B is more of when the board does have discretion, here's the criteria we look at to assess whether or not it will qualify. But here again, I need, this is helpful for me so I can craft better language.
I just thought it might clarify it to say approval as an accounting course or.
I think it's nested appropriately as 1B, but perhaps we can add a, kind of a clarifying phrase at the beginning of B, like for courses that need to be considered by the board for approval, or something. We can tweak that a little bit, but maybe an intro on when B applies, because I think it is appropriate to modify section 1.
What about in B, in the second sentence of B, if we said the board will consider the following factors in determining whether other courses qualify? Add the word other. That help?
Yeah, I think so. Just language stating that, if it's not clearly listed above and the board's exercising its discretion, this is what we will use. So I can make that clear. This is very helpful feedback, though. Thank you all.
Hey, going back to the earlier question on data analytics, which shows up, I think, in 2 places in this draft rule. I interpreted it that context would modify all 3 of those items in the series. But if it helps, we could say something like data analytics and accounting context, including data interrogation techniques and or digital acumen, comma, and then leave the rest of it. So you could just kind of flip some of that so it's clearer, more clear. But Maria, I'll leave it to you. But I did interpret it that modifies all 3 items.
Thank you. Yeah, and I can make that change so it's more clear.
Nothing like group editing with the lawyers. Lucky bunch here today.
It's the greatest thing in the world.
Okay, so I'm going to move on to D. I think we've given ourselves something to think about on A and B. Oh, I'm sorry. Let's look at C real quick, because although there's not an addition or deletion, I want you all to know that in C, we say that not more than 6 semester or 8 quarter hours may be internship programs, which may be applied to the 30 semester hours in accounting. So the model rules has increased that to 9 hours, but they're only allowing some of those hours to count towards accounting. So we didn't feel like we needed a change there. Because even if the person got more internship hours on their transcript, we would count those as other hours. And they seem in the model rules to restrict, even though you can get more, they restrict the number that can count towards accounting. So we just suggested that stay at 6. Does anybody have concerns with that? Okay. Okay. In D, we talk about the number of business hours needed for licensure. So at least 24 semester or 36 quarter hours in general business education and one or more of the following. And so the blue wording is your additions. So in number 5, we talk about an ethics course, and we clarify that it's a business ethics course. If it's accounting related, then we would count it towards the accounting requirement. And then in 10 and 11, we add the data analytics wording similar to what we had in accounting, because it would also count here if you already have enough accounting hours. And then any other business related content areas included in the CPA exam blueprint or as may be approved by the board. Any questions there? Okay, and in number 3, so this is wording that we added based on prior decisions of this board. This is not model rule language. But in number 3, we say for purposes of this rule, candidates must have at least 24 semester hours of accounting courses at the upper division level, junior level courses, or higher. The added wording would be lower division level courses, including those completed at a junior college that transfer to a senior college as upper division level, may be counted as upper division level, provided the transferred credits are listed on an official transcript from the senior college. For those of you who've been around for a few years, we had a couple of years where I felt like we had a lot of people asking for their community college courses to count towards upper division for one reason or another. And we denied all of those. And so it is a stance of this board that if you take something at a junior college, that unless it transfers and it shows up on the transferred college's transcript as an upper division course, we do not count that as upper division credit. And so we added that wording there to try to be clearer to the applicant if they question or ask for the requirements there. Any thoughts or questions on that? Okay. Oh, and that's it. So it sounds to me like we need to look at that section under education a little bit more and see if we can work on that wording. And I've taken notes. I know Maria has too.
That last section you talked about, Wendy, and this, I guess maybe Pam can answer this question. Is senior college a correct terminology to use there? We're talking about junior college, and then we said it has to be, we used the term senior college there a couple of times. Is that an accurate term?
I am not familiar with that term, which doesn't mean it's not appropriate, but I'm not familiar with that.
Okay, Larry, I'm glad you brought this up because Todd brought this up in his review as well. And so I'm happy to change it accordingly. However, in crafting that language, we, usually say college and you think of 4-year degree. And so because we're distinguishing between the junior level and the senior level, I put senior level to indicate that we're talking about a 4-year, degree granting institution, which I just Googled like the, Webster Merriam definition of senior college, and it was a 4-year program. And so I did that just because, like I said, we're delineating between the junior level there and lower level division courses and senior level. I'm happy to add, different language if there's something that's more clear. I just didn't know how to, make that come across without using the senior college.
I don't know of a better term. It just sounds like a big boy college or something, senior college.
I guess in relation to a junior level, or junior college, and then the lower division courses.
Yeah, I get what it means. I just had never heard that term before. I've heard
Larry, it's a college for senior aged people, retirees.
I understand.
But I think it's usually just, what you said, Maria, it's usually just a 4-year degree granting college or university, but senior college sure is more concise.
Well, would it be more appropriate to use the language, a 4-year degree granting college, something like, because I would think that would be confusing, a senior college. I don't know that I'm not familiar with it either.
We can do that. Are there any 4-year granting, 4-year junior colleges don't do that. Community college don't do that, right? So there wouldn't be confusion there, right?
I don't think so. I have other boards that use the term 4-year degree granting institution. So I can switch that out for the senior level reference.
Okay.
Wendy, my only question to using 4-year is it really 4 years or is it 150 hours? A lot of kids, it ends up being a 5-year. So do we get messed up using 4 years?
I think we're just trying to define the type of institution, not the requirement to be licensed. That's how I see it. We're trying to define the institution.
Okay.
Good luck
And
on
Wendy,
that.
maybe we could. Oh, I'm sorry.
I said, good luck on that one, Maria.
It shouldn't be that bad. I think maybe we could run it by NASBA as well. They've been super helpful in this process. And so they're so familiar with what other states use as well that, they might have a suggestion or they might give us a go ahead on that.
Okay, so I guess, Wendy, the determination on this item is that the committee and actually the full board has made some recommendations for legal to come back with another version on some of the areas. I don't think we can approve this today with as many suggestions as we have. I
agree, and I'm not sure that we have the time for Maria to put enough thought into revisions. So is this something are you all okay if we take the feedback and bring this back to you at the next meeting?
Yeah, that's kind of what I was thinking.
And then I wondered, and I'm kind of curious what Pam thinks about, any other parties that we might want to share this with. Is this something that you think educators should take a look at before we move forward with it? Would we invite them to our next meeting? Any thoughts on that?
I think it could be appropriate for maybe you to contact department chairs at several of the 4-year degree granting schools to see if that wording is if there are any problems in there, because they have changed how they deal with junior college courses so much over the past, say, 10 years because of laws in Tennessee that have changed, et cetera. So I think that would be good both from the perspective of identifying anything we haven't thought of, but also, from a, not PR, but just community building perspective to let them know we are doing this to clarify for them, not that we're trying to zap them.
Wendy, would it be, and I think if Kara's on the line, I think the Tennessee Society has an education council that we have had presentations to before. That might be also a very good venue because I think it represents a number of institutions in Tennessee here to kind of provide, an opportunity for their knowledge and feedback.
Kevin, that's definitely something that we could work with you guys on. I know we were planning another event for educators in August or September. That might be a little bit too late for this, but we would be happy to work to coordinate another event in conjunction with the board to discuss this.
Thanks, Kara. We'll perhaps, I think, work with Wendy and just try to sort out the breadth of the revisions that we've talked about today, and then determine the urgency level, whether we really need to act at a July meeting or not.
Sounds good to me. We can work on some changes and we'll go from there and take all those items into consideration and figure out a good time frame.
Okay. Thank you, Wendy, for that great explanation and detailed analysis, because that's a much better job than I could have done. Appreciate it.
Larry, thank you for leading the committee here on the discussion on this. And I think, are there any other items of business for the Laws and Rules Committee?
Don't think so. I think that's it.
Okay, thank you, Larry. I think the next report is out from the Executive Committee, and that's our finance report. And some of that was included in the read ahead, or I believe all of it was. And Wendy, would you like to summarize any highlights that you'd like to bring to the attention of the members of the board?
I'll just try to do a quick overview of where we stand with our financials. So far this year, we have revenues totaling $874,960. Our expenses are coming in at $564,153. We're on the positive side at $310,000, $310,807. Fiscal year ends June 30. These financials in front of you today are for the period and for the year ending February of this year. And I have done a detailed kind of breakdown of where we stand on all the items, all the revenue or all of the line items. So there's a couple of things I'll point out. From revenue, we are down in revenue about 4.5% or $44,000 to the prior year. We had a lot of IT issues this year, and we had some in February, which caused us problems getting out our notice that we send once a late fee has been applied. So typically those would go out on February 1st, and it took us really a month to resolve those issues. And so those notices didn't go out until the very end of February. And our revenue for February was down a little over $40,000. And so we had very little activity that month, which typically we would have once people receive those notices. So I do think that we're going to see an increase in once we get our March financials to kind of make up some difference there. So don't think we'll be that far behind. Our case and complaint revenue is down a little bit. Of course, we've had less complaints this year. And so we are down 26% there, or $44.50 to the prior year. So a lot of other areas you'll see that are very favorable to the prior year and favorable to the budget, just because we haven't had the expense. Travel, obviously, employee training is NASBA registration fees typically falls there, as well as CPE that staff might need. Sherry has been able to find most, if not all, of her CPE free of charge and with various avenues, and so we haven't really had any expense there this year. So the last big area to note is the last line item is state professional services, and we are at $44,000 there, a 69% increase over the prior year. And after doing a little research on why we're so high there, I found a few things. They've increased our rent, which they had not made us aware of. So we were looking into that, but we have an increase in our rent, about $2,000 over last year, year to date. Changes in how we've been billed for our state car. So Sherry, because she's not out on the road during the pandemic, they changed the way they charged us from a usage to just a fixed rate every month. So we did see some changes there, and that's a little over $3,000 year-to-date increase from the prior year. We also have those informal hearings, which have been very successful in preventing us having full formal hearings, but we do have to pay for those judges when we have those. And so we did see some charges there, a little over $1,000 that we had not seen in the prior year. And then the big one is an increase in IT charges to the tune of about $9,000. There have been a lot of, you've heard me talk about IT issues that we've had. A lot of that was related to an upgrade of our platform back in the fall, and there were significant issues across all the boards. And so this is our share of it, both in terms of shared expense as well as expense related to our program specifically. And so I don't have any more detail behind that, but we are watching it from an IT standpoint. And other than that, our cost backs are actually down to the prior year. We are doing better with regards to legal costs. I think the move to having just Maria representing our board rather than two attorneys has helped us. Our legal costs are $19,000 less than the prior year. So I think we're able to maintain that better and receiving the same level of service there. So I think that's a good thing. And I think that covers my report on the specifics for the financials. Does anyone have any questions?
So Wendy, when you get your crystal ball out, where do you think we'll be at year end? Do you have any predictions on, I mean, I know you can't peg it exactly, but you've already been through the month of April now.
Yeah.
You've already been through March and April. So what do you think at year end will be looking like? Bottom line.
I would say that we're still going to be putting 75 to 100,000 into reserves.
Yeah.
And keep in mind, we haven't had any travel this year, and so that's that expense. So things that some expense that we would normally have, but even if you had thrown that in there, I still think that we would have been fine.
So when we do our budget for next year, who does it go to for approval? Does it go to the state? Does the state approve our budget or not?
They don't technically approve it or advise me of an approval. I do submit it to the department heads, and it kind of gets inputted as our budget. So you all approve it, and I've never heard anything back necessarily at the department level once I submit it.
But they do determine the salaries, right? We have no control over the salaries.
Right. So yes, that was another thing. I'm sorry, I forgot to mention. Of course, the state did not provide salary increases this past year due to the pandemic. So there was no increase there. Correct. The board doesn't, I usually chart it out for you on what it's going to look like based on what we think might happen with salaries.
So I mean, if you're looking
Mary,
at,
this is Kevin. I'm sorry, go ahead.
If you're looking at the expense items on here, the 2 or 3 biggest items we have no control over, such as if you're looking at the expenses, salaries, the benefits, and so forth. So, and we don't control those.
Correct.
So I guess I was just thinking about, in looking toward future budgets, is there some way we could better utilize our revenues in the way that we'd like to see it spent rather than the way somebody else wants it spent? But you're saying we can't change that, salaries and so forth, in order to keep from having the surpluses.
Right.
Is my point.
Right.
Could we affect our staff salaries to utilize some of that surplus? but I think the answer is no.
I would believe that that's probably the answer. Yes, we can always check into it, but I know for sure the staff salaries they're likely not going to. Now Sherry and I report to the board, so that could be an area, but I don't know that historically the board has had except
When I
upon
say,
hiring.
yeah, when I say staff, I'm including, you know, all of you
Right.
and your staff.
Right.
Okay.
Yeah, and Larry, the one other thing I would say is that when our board sunset hearing occurred before the Joint Operations Committee, I guess now it's been a year and a half ago, pre-pandemic, the reserve levels of the various boards that were coming before the Joint Operations Committee up at the legislature were the subject of scrutiny by the Joint Operations Committee. And at that point, when we had our sunset hearing, our reserve level was roughly equivalent to 1 year's or thereabouts worth of operational capability. And that did not appear to be a cause for concern with the committee at that time, but they do monitor it. And you're right, there are the most significant elements, at least on the expense side, we can't control or don't have direct control over. But we can continue to look at that. And the other thing I would say is that there is the potential for reserve harvesting. I mean, that's really an executive and legislative branch decision that would also be outside of the control of the board.
Yeah, that's what I'm concerned about.
Yeah.
You know, I don't mind if there's nothing wrong with having surpluses, and there's nothing wrong with building surpluses. But in our case, if it's going to be used for the benefit of our board or for the benefit of our members, that's one thing. But if it's going to be swept and used by the hairdresser's board, that's something else. So I'm just saying, is there anything we can do to look at these line items in next year's budget to try to utilize it more for the benefit of our accounting professionals as opposed to other boards? That's my only point.
Yeah, and that's a fair question, I think, Larry. I think what the board has more control over would be the level of fees, that we would be charging our members, as opposed to some of the expenses such as salaries and benefits, which are really not decided upon directly by the board.
Okay.
The other thing to note is this has just been a really odd year. We hopefully we do get back to travel. Hopefully you'll see there's nothing under computer related items. I feel sure that most of us are going to need our computer. A lot of us have been having computer issues. We've had them for 4 years or so now. And so I know there is a rotation schedule for that. They may all hit at once. So there will be some expenses that we did not see this past year that we will likely see going forward. But yes, we can certainly talk about some of that. We'll do that in October.
Okay, thank you, Wendy. Any other questions for Wendy about the overview of the financial picture here?
I've got a question just to Wendy on something she just talked about. With the surplus we're going to have this year, or looks like we're going to have, is there a way to move those IT purchases ahead and go ahead and make those this year? Since you're already having issues with the computers, can we push them to go ahead and say, hey, we've got the money, we'd rather go ahead and just do it in this year's, out of this year's?
I can certainly look into what the abilities are for us to do that. Sure.
Okay. Because I think that anything IT you need, now's the time to get it and go ahead and get it ordered, because I think the state's going to catch up with a lot of IT issues, and it would be good to go ahead and just get that out of the way so we know what we're dealing with next year.
Good thought.
Yeah.
That's the kind of stuff I'm talking about, Andy, that we could be looking forward to try to utilize for our profession's benefit as opposed to throwing it into a reserve. Good idea.
All right. Wendy, any other items here in terms of preparation for tomorrow's actual board meeting?
I do not have anything.
Okey-doke. Well, I think I don't have any other business for our committee meetings, and so we'll get a little bit of time back in our afternoons. The one thing I would say with respect to, meeting remotely here, we appreciated being able to work with Wendy, also with Assistant Commissioner Alex Martin. I think Todd was providing some guidance as well, given his perspectives in terms of whether we could or should meet remotely or in person for this May's series of meetings. And it was a little bit dicey because of the April 30th expiration date of the governor's executive order, and likely not knowing until after we had to public notice this meeting what would be the disposition of that order, whether it would be extended, modified, or allowed to expire. And so we made the decision. I know Wendy had polled board members as to their ability to meet, and just very much appreciate your flexibility with respect to this. We're hopeful that we will be able to meet for those who feel comfortable doing so in July in our normal regular meeting on an in-person basis, because it's been far too long since we've had a chance to get together in person. And just want to thank everybody for their patience and forbearance as we've kind of worked through this and a host of other pandemic related issues on this board and in our professional and in our personal lives. So with that, we'll go ahead and adjourn our committee meeting session today and look forward to seeing everybody tomorrow morning for our full and regular board meeting. Thank you all.
Thank you, Mr. Chairman.
Thank you.
Thank you.